So just in case there's any issue with the meeting, I just request everyone to kindly just join back. It just happens with Zoom. So very humbly, very warmly, I welcome everyone who has joined us today for this another class of this Humble Free Legal Literacy Initiative. Um, I also wish you all a very happy Mother's Day today. And I thank our esteemed faculty member, Shri Prashant Bhushan sir, today for gracing us and taking us through this concept of public interest litigation. So again, I'll not be speaking much. I'll just hand over the class to sir. But irrespective, sir does not need a very elaborate introduction. For that, we've already shared sir's brief profile and sir's Wikipedia page. So anyone who wants can, and very humbly I request that everyone may kindly also just go and see that also. But I will still just do my little bit in trying to introduce sir. Mr. Bhushan is the oldest of four children of Shri Shanti Bhushan and Srimati Bhushan. His father was a lawyer activist and a former union law minister in the Morarji Desai government. Mr. Bhushan was educated at St. Joseph's High School, Allahabad, and at the St. Joseph's College, Allahabad. Mr. Bhushan dropped out of IIT Madras after his first semester and briefly attended Princeton University. He has a degree in law from Allahabad University. While still a student, Mr. Bhushan wrote The Case That Shook India, a book on the case that set aside Indira Gandhi's election in 1974. Mr. Prashant Bhushan is an Indian public interest lawyer in the Supreme Court of India. He is the convener of the Working Committee of the Campaign of Judicial Accountability and Judicial Reforms. He is also associated with various organizations, including the Center for Public Interest Litigation, People's Union for Civil Liberties, and Transparency International. Sir, I very warmly welcome you, and I request you to kindly take us through this class today.
Thank you. Thank you, Keshav. It's my pleasure, and good morning to everybody. It is my pleasure to be with all of you to discuss an important issue for lawyers, which is public interest litigation. Now, I'll get straight into the issue. Public interest litigation, as the name suggests, is litigation in the interest of the public, and litigation in which the people for whom you are going to court or who are going to be benefited by what you are seeking in court are not necessarily the petitioners or the people who have come to court. You could be, the petitioner could be one of the beneficiaries of what is being sought. On the other hand, he may not necessarily be one of the beneficiaries. For example, I mean, there are broadly two kinds of public interest litigation. One is public interest litigation in the interest of a defined section of society, which is not in a position to approach the court themselves, which is too weak. For example, jhuggi dwellers, street vendors, rickshaw pullers, prison inmates, etc. These are a defined class of people who may not have the wherewithal to approach lawyers or to pay lawyers, to approach the courts on their behalf to litigate their rights. They may not even be people who are aware of what their rights are in this situation. So therefore, public interest litigation is a tool which has been devised for such class of people, where anybody can espouse their cause and go to court on their behalf. And then the courts have said that there will be no question of locus standi when somebody approaches the court bona fide on behalf of such weaker sections of society who are unable to approach the court themselves. Because otherwise, the rule, they question your locus, how are you affected, how are you involved in this case, what is your interest in this case, etc. But those questions are not supposed to be asked when you are approaching on behalf of weaker sections of society. Then there are those public interest litigations which are not on behalf of any particular defined section of society, but are on behalf of society as a whole. For example, corruption. Now, corruption is a problem which affects society as a whole. You can't say that if you are going to court saying that there is corruption happening in this and the authorities are not doing anything to stop it or to hold those who are involved in corruption accountable, then you can go to court and seek that, because it has been held that corruption is an issue which affects society as a whole, and therefore anybody can approach the court on an issue of corruption in public interest. Similarly, environmental issues. So if there is some activity which is harming the environment, because environment is also a general issue, especially today in the age of climate change, where any carbon emission anywhere is going to affect the general climate of the world everywhere. Of course, environment may also be sometimes local. For example, solid waste pollution may be a local issue which affects only people living around that, etc., or mainly people living around that. But it's something which does not affect any well-defined section of society. So public interest litigation consists of all these kinds of litigation, where you are either going on behalf of some defined section of society who are weak and unable to approach the court. I think you'll have to ask the people to either mute or...
I will have to start removing people if this continues. I very humbly request that everyone may kindly just keep the mics on mute. I know everyone then a very esteemed guest, but please ensure that your mic is on mute. And everyone, all the co-hosts, I request you kindly just ensure that. So I request you to please continue.
You can probably, as admin, mute everybody for the time being, till such time that we get into question answers.
Absolutely. So you also become mute.
Yeah. So I have unmuted. Yeah. So these are broadly the two kinds of public interest litigation. So there are public interest litigation involving environmental issues. It could be issues relating to air pollution, water pollution, solid waste pollution. It could be issues relating to carbon emissions, climate change. It could be any general issue relating to ecology, etc. So there is that class of litigation where the courts have recognized this and intervened in many cases involving environmental issues, because they have held that having the right to have a clean environment is part of Article 21 rights of people. That is, the right to life includes the right to live in a clean environment, the right to have a decent environment, etc. That's Article 21, part of Article 21 now recognized. Another generalized subject of public interest litigation is corruption, which has also been recognized and used by the court quite a bit, especially in cases like the 2G scam or the coal scam, etc., where the court gave various directions, including the directions to investigate and prosecute those people who were involved in the corruption in the 2G scam or in the Colgate scam or in various other scams which have come to the court. Environmental issues, of course, include such things like nuclear power plants, electric vehicles. There is an ongoing litigation that we have filed saying that the government is not even implementing their own norms which they have laid down for giving a fillip to the use of electric vehicles, etc. Then there is public interest litigation involving institutional reforms. These are also generalized issues. There are several litigations that have been undertaken for institutional reforms. For example, in the reforms relating to making the CBI independent of the government. That was in Vinit Narayan in 1997 or 98, when the court held that in order to make the CBI independent, the selection of the director has to be through a particular process, not be left in the control of the government alone, where they also held that the CVC should be given statutory status and the CBI should be placed under the supervisory control of the Vigilance Commission, etc. So there were several directions which were for institutional reforms of the CBI. Same thing or similar things were done in the police reforms case filed by Mr. Prakash Singh, where the judgment came in 96, where the Supreme Court gave a slew of directions about, or 2006, the judgment came in 2006, and the directions were about appointment of DGP, about putting in place state security commissions, about putting in place police complaints authorities, setting up police establishment boards, ensuring a minimum tenure to the DGP and other field level officers in the police, etc. It's another matter that most of those directions which were made in Prakash Singh still remain unimplemented and are often being flouted by various states, etc. We have filed several contempt petitions in the court relating to that, which are still pending. Then there were institutional reforms, judgments involving appointment of the Central Election Commission, which has come very recently, where they have held that the appointments of the election commissioners cannot be in the hands of the government alone and would be done by a committee consisting of the Prime Minister, Leader of Opposition, and the Chief Justice of India, in order to make the Election Commission somewhat independent or more independent of the government. So there were also institutional reform judgments in civil services in TSR Subramaniam's case regarding tenure and transfers of civil servants, etc. It's another matter that despite these fine judgments, many of these judgments are being flouted by the governments or have not been implemented, and people have gone to court pointing out that these are being flouted and therefore contempt petitions are pending. And it's unfortunate that in most of those cases, the courts have not really cracked the whip in order to ensure the implementation of those judgments. Then there are public interest cases involving sort of weaker sections of society, such as prisoners in jails. There are several judgments which the Supreme Court has given regarding the conditions of the prisoners in jail, not handcuffing them, treating them with dignity, as well as about their release if they have fulfilled, if they are under trials, and if they have already spent half the maximum time which they can be awarded by way of punishment, then they need to be released. There are also judgments regarding street vendors or the rights of street vendors. And in fact, sometimes as a result of the judgments of the Supreme Court on such issues, there are legislations which follow that. So the Street Vendors Act, which came, was also pursuant to judgments delivered by the Supreme Court. Similarly, the Right to Information Act also to some extent came pursuant to several judgments of the Supreme Court when they had held that right to information is actually part of Article 19(1)(a), right to freedom of speech, and the right to be of the citizens to be informed about what the government, which is there acting on their behalf, what it is doing, etc., on their behalf, is a fundamental right of the people under Article 19(1)(a). And to some extent, the Right to Information Act, which came, was a result of several judgments of the Supreme Court on that. Then there were judgments regarding the rights of Chuggi dwellers, about the need to provide them basic housing. There are judgments on the rights of the homeless, about the right to have a shelter for the homeless, etc. So there are a slew of judgments in public interest litigation involving the rights of the underprivileged who are not in a position to approach the courts themselves. And in these judgments, the Supreme Court has also expanded the interpretation of Article 21, which is the right to life, where they have held that the right to life is not just the right to an animal existence, but it is the right to live with dignity and everything that is required to live a life of dignity, which includes food, shelter, health, basic education, etc. Then, of course, there are several hybrid cases which involve environmental rights along with social rights or the rights of the underprivileged. For example, the Narmada Bachao Andolan case was a case which involved issues of environment, because it was the case of the NBA that the dam would very, very adversely affect the environment of that whole river and the ecology of the whole Narmada River. And it would submerge a lot of forests and several important historical monuments, etc. That was one part of it. The other part of that case was that you cannot displace these people without providing them with a decent alternative. That is, even if you have to displace them, you must displace them only after you have provided them with a proper alternative place where they can be resettled. So NBA was one of those hybrid cases which involved similarly mining. There have been several public interest cases regarding mining in iron ore mining or coal mining in various states, etc., where rampant illegal mining was going on. Now, that case involves issues of corruption. It also involves environmental degradation. It also sometimes involves displacement of the local people who are being displaced on account of the mining activity. And in some of these cases, some very important principles have been laid down. For example, in the mining cases, they have laid down a very important principle of intergenerational equity, which is that the present generation has no right to consume all the natural resources that are there on the planet, and you must leave these resources for future generations also. So like the principle of being able to live in a decent environment, this is also a principle which has been evolved, which is called the principle of intergenerational equity. That is, you must have equity for future generations also. Now, some of the problems which have been raised, or some of the issues which have been raised about PILs. One issue which is sometimes raised is, though the court has held that locus standi is not an issue, is not a bar for a PIL, which means that anybody can approach the court bona fide. But in many cases now what we are seeing is people are raising the concern that, look, this is a politically motivated case, that this person is inspired by some political party or some vested interest, etc. It's a case inspired by some vested interests who have some vested interest in this issue. Even if it's an issue relating to corruption or any generalized problem that the person might bring up. And there sometimes the courts have started saying, recently at any rate, have started dismissing PILs on the ground that this is politically motivated. I'll give you one example. Recently, I was doing a case regarding a quo warranto against the present Vice Chancellor of Allahabad University. Now, the petition was filed by some social activists, and issues were being raised by the university and by the government that, look, what is his interest in the matter? He must be having some vested interest in the matter, etc. But strictly speaking, these kind of objections cannot be allowed to be raised in a public interest litigation where the cause that the person has brought to court or the cause that he is espousing is a genuine cause. Then these issues should not be allowed to be raised. But sometimes I find that recently courts have started raising these issues and have started dismissing petitions on this ground. Here, the correct solution, in my view, is for the court to appoint an amicus. If you feel that the cause is genuine, but the person is suspicious, sometimes it may happen that if the person is suspicious, he may use that petition as blackmail, and as soon as his interest is served, he may withdraw. So therefore, in order to prevent that from happening, the court should appoint an amicus, who should be, amicus means some lawyer or somebody who takes over the litigation from that person, and thereafter pursues that in general public interest, so that the control of the litigation is taken away from that person and handed over to this amicus, so as to prevent him from withdrawing after his purpose is served or after the other person pays him off, etc. This sometimes is happening. In fact, one of the recent cases that I was doing, somebody had come to me regarding these chit fund scams, etc. in Odisha. Now, later I found that that person has a somewhat dubious background, though the cause that he had brought was genuine. So I myself went told the court that, look, I have found that this person has a somewhat dubious background, and therefore you should appoint an amicus in this case. So that was a case where an amicus was appointed. The other issue that is sometimes raised in public interest litigation is what is called constructive res judicata. So what happens is that somebody files a half-baked petition. Say some people, for example, there is one gentleman called M.L. Sharma who files a lot of half-baked petitions on all kinds of things, and he gets those petitions dismissed without the court even examining the real issues which may be involved in the thing that he has brought to court. For example, on this Hindenburg, Adani, some PILs were filed. Now, some of them were half-baked. Now, if the court dismisses those petitions without getting into or without dealing with the issues that could have been raised or should have been raised in that case, then sometimes it is argued that when a genuine PIL is filed on that issue and the people bring the real issues involved in that case before the court, then the court says, okay, look, this on this prayer or on this issue, a PIL was earlier dismissed, and therefore this is barred by constructive res judicata. So recently, Justice Chandrachud has delivered a very good judgment in the case of the National Confederation of Officers Associations about 2 years ago, in which he has said that constructive res judicata cannot be applied in PILs, etc. And the court has to see whether the issues raised in this petition have been were properly addressed by the court in the earlier case and dealt with by the court in the earlier case. And if they have not been dealt with in the earlier case, then this PIL cannot be dismissed on the ground of constructive res judicata. Then there is also a problem of sometimes courts dismiss petitions with heavy costs. For example, we had gone to court on behalf of the Campaign for Judicial Accountability, seeking an independent investigation into a corruption case involving where the CBI had registered an FIR and the CBI was investigating, which involved the then Chief Justice of India. So we said that it is dangerous to leave this investigation against a Chief Justice in the hands of the CBI, which is still essentially a government-controlled body. And therefore, the court must appoint an SIT for this investigation so that it remains with an independent body. Now, unfortunately, that petition not only came to be dismissed, but costs of 25 lakhs were imposed on the Campaign for Judicial Accountability in that case. It was totally mala fide in my view. It was Justice Arun Mishra's judgment, and he was acting obviously in connivance with both the government as well as the then Chief Justice. So these are some problems which do take place. Now, lastly, what is the duty of a lawyer who wants to bring a public interest case to court? This is very important. So first, what does a lawyer who wants to bring a public interest issue to court needs to do? The first and the most important thing is that he needs to carefully think of what is the prayer that he wants the court to grant. What kind of order does he want the court to issue? That's the first thing that you need to think of very carefully. So you have to go to court with a problem and also with a solution that you are proposing. Because when you are seeking a prayer, you are effectively pointing out that if the court issues this order, then this may mitigate or solve this problem of public interest. Where public
Thank you.
So that is the first thing. That is, you very carefully think of the solution of the problem. Suppose you go to court saying that there is a lot of corruption in this country, please do something about it. The court will say, of course, we know that there is a lot of problem of corruption. There is a lot of corruption, but what I think you'll have to mute.
So you're also muted now, unfortunately.
Yeah. Okay. So you have to carefully think of the solution. So you may say that, look, there is a lot of pollution. The court, and therefore you brought a PIL to court. The court will say, yes, there is a lot of pollution, but then what can the court do about it? So you have to go to the court with a proposed solution. So you have to not only bring the problem, but think of the solution and then approach the court, because the prayer would be what you consider to be at least a partial solution to the problem by way of a court order. The second thing that you need to do is, you have to go to court when you file a PIL. You must remember that if you file a half-baked PIL and the PIL comes to be dismissed, then you are damaging future people who might be wanting to file a PIL or who might file a PIL in future on that issue with much better information, with much better research. So therefore, it's important for before you file a PIL that you need to do the best research possible on the subject. Consult the best experts who are available on that issue. And after discussing all the pros and cons with them, then only you file the PIL. And of course, lastly, you must also point out what is the fundamental right that is being violated because of this problem that you have brought to the court. How is this issue actionable? What are the rights of which people that you are seeking to enforce? Whether they are fundamental rights or any other constitutional rights or any other rights, you have to point out what is the legal basis for the courts to intervene, because otherwise the court says that we have no jurisdiction. So one question which sometimes arises is, which people raise is, can a policy be challenged by way of a PIL? Yes, a policy can also be challenged by way of a PIL, provided you can show that that policy is illegal, unconstitutional, violates some fundamental rights. Because no policy can be framed or can be executed by the government which is in violation of fundamental rights or the constitutional rights of people. So therefore, these are just some preliminary thoughts that I had, which I thought I'll share with you on public interest litigation. However, I am happy to answer questions for the next till about 12:30, after which I'll have to leave.
So again, thank you so much. Very enlightening. Actually, I see that you've covered all aspects of it, not just any directional perspective. So people, again, they love you a lot. So a lot of commotion during the class also. I'll say straight away, I have a lot of questions, but my questions I will take towards the end of it. First, sir, there is this question by Arivazagna ji. Namaskar. Would you be wanting to ask your question, or should I ask your question for you? So, sir, I think I'll only take the question. In the meanwhile, I request everyone that who want to ask, kindly raise your hand so that you may ask the question yourself. So, sir, their question is, what's the reliable role of RTI Act in public interest litigation? And what is the position of RTI Act today?
Yeah, RTI Act can play a very important role in public interest litigation, because in public interest litigation, you need to go to court with the best possible information. Suppose you are raising an issue of corruption, you need to know exactly or you should know, or you should try to know what is it that what happened with the government, why did the government decide to do this, whether any people raised objections to this within the government or not. Under the RTI Act, you can ask all those questions, and even the file notings should normally be disclosed under the Right to Information Act. However, it's unfortunate that many public authorities today are not doing that, are not even following the Right to Information Act. Against that, you can appeal to the information commissions. Unfortunately, many of the information commissions are either dysfunctional because of lack of members in that commission, or sometimes because they consist of only retired government servants who are not independent enough, because the appointments of election commissioners are also not being very properly made, despite the fact that in a PIL filed by Anjali Bharadwaj, the Supreme Court had ordered some degree of transparency in the method of appointing information commissioners, which said that you must put out a shortlisting criteria, you must advertise the post, you must put out the people who have applied for it, you must put out the short list, and so on, so that people know what's going on before the appointments are made, and they can raise objections or give their comments, etc., to various proposed shortlisted appointees. So that's the position.
So, very elaborate. I think that answers the question quite well. Mr. Kishan Kumar, sir wants to ask a question. Kishanji, would you want to ask the question yourself?
Hi, yes, sir. Am I audible?
Yes,
Yeah.
sir.
Yeah, thank you so much, first of all, for arranging all these knowledgeable sessions. And we are really, really honored to be here. And thank you so much, Prashant, sir. It was my first experience to listen to you live on the webinar, and I'm really, really feeling very blessed. And at the same time, I want to utilize this opportunity to seek your, knowledge and the experiences that you have so far. So my question is not very deep, but it's just an overview because I also wanted to know more about the RTI. So my question to you, sir, is that what are the major challenges that usually people who try to file the RTI, they not just the RTI but also the PIL in India. So what are the major challenges that people face when anybody thinks of just lodging an PIL in the court? And also, if you could share any of your personal experience that you had, because like I would say, a couple of days ago we were discussing your case wherein it was an amazing judgment wherein we saw that there was just a fine of 1 rupee. So it was it was the beauty of the judiciary system that we have, and once we have the good knowledge, and definitely we can provide justice to the society and to the people. So just one request that if you could share your personal experience when you had challenges while filing the PIL, or if you could just guide us a little bit more on what could be the challenges that we may assume that when somebody is planning for the PIL.
So as I said, just see, the most important thing is to first think of a solution. You don't just go to court with a problem. There are so many problems, but you have to go with a solution and to find what is the correct solution to that problem. And then you have to show that this solution is judicially manageable. That means that the court has the jurisdiction to grant you such a prayer because it's a legally justiciable issue. There are rights involved which are being violated. But the most important thing is to get the best possible information and understanding of that issue from the best experts in the field. So you must, when you are thinking of a PIL, you must always go. For example, we recently filed a petition regarding the retrieval of funds of people who have died by their legal heirs. They may have bank accounts, they may have shares, they may have other funds and deposits in various places. The legal heirs firstly don't even know who is where those funds are of the person who has died. Thereafter, they find it very difficult to retrieve those because they have to go to court, get a probate or get a succession certificate, letters of administration, etc. It's all a cumbersome process. There should be a much simplified process for firstly finding out and thereafter retrieving those funds. So when somebody brought this issue to me, I began to think of who could be the people who have the best understanding of this. So we did a search on the internet to see who has written about this issue. We found that this lady Sucheta Dalal has written a great deal about this issue. She's the one who had exposed the original stock market scam of Harshad Mehta and thereafter Ketan Parikh also. And she has been tracking this, writing about this. So we approached her to get her understanding of it. And after discussing it with her, we filed a PIL on her behalf in the Supreme Court, which is still going on, which is still pending. But this is just an example of what you need to do when you want to file a PIL.
Thank you so much. Thank you so much, sir. Really appreciate it. Thank you.
Thank you, sir. Thank you, Kishanji. Sir, Mr. Sanjay Pinto wants to ask a question. Sanjay, sir, request you to kindly ask the question.
Good afternoon, sir. Sir, courts are meant to uphold our fundamental rights. but we often find, and you've touched upon this issue in your presentation, and I'm glad you did, that the imposition of costs, in my opinion, cast a chilling effect on Article 19(1)(a). I do understand that sometimes publicity interest litigation also sort of masquerades as PILs, but in many cases, this trend of awarding costs, of imposing costs on litigants, would have that chilling effect and would negate the very role that the court is meant to play as an upholder of our fundamental rights. What is your take, sir?
No, I agree that it can have a chilling effect, and sometimes costs are very unfairly imposed, like in our own campaign for judicial accountability petition, which we had filed with a perfectly legitimate prayer that the investigation against the sitting Chief Justice cannot be left in the hands of the CBI, should be in the hands of an SIT formed by the court, so that it cannot be used as an instrument to blackmail a Chief Justice, which would be very dangerous in a democracy. Yet that petition was dismissed and heavy costs were imposed. That was, of course, a mala fide judgment. It was a judgment in which both the government as well as the then Chief Justice was interested. And they found a convenient hatchet man in the name of Arun Mishra, who became the hatchet man for several Chief Justices in several cases, including the sexual harassment case against Gogoi. So, of course, I'm not saying that costs should never be imposed when dismissing a PIL. There are unfortunately a number of people who file PILs which are half-baked and file them for publicity. There are also occasionally PILs which are filed for blackmail, which means you file that PIL, thereafter you enter into a compromise with that person against whom you have accused of corruption, etc. You take some money from him and thereafter withdraw your petition. So in those cases, of course, as I said, amicus should be appointed where there is suspicion that this person has entered into some kind of compromise. But in some cases, yes, costs can be imposed, but it has to be very, very carefully and judiciously done.
Sir, if you may permit me, if I have another small question, subject to the others who are waiting, I can wait for my turn at the end.
Yes, sir, please just go ahead right now if you can ask.
Sure. Thank you, sir. So, to what extent can the doctrine of sufficient interest be expanded in PILs?
What do you mean by that, doctrine of sufficient interest?
Because I think in the H.D. Khanna case, this was propounded many years ago in the Supreme Court. I don't have the exact citation, but where the courts feel that, in what way are you, even if it's a PIL and not a writ petition, they feel in what way are you affected for you to come to the court in terms of what is your act time?
In a PIL, they can't ask how are you affected, because courts have held in so many cases that locus standi cannot be an issue which is raised in a PIL. Only thing that they need to see is that it's bona fide. If it's mala fide, for example, or even if it is half-baked, they can dismiss it on the ground that this is half-baked. You have not come with any kind of research, etc. So therefore, we dismiss it. They can also dismiss it if it's very clear that this mala fide is used as an instrument of blackmail, etc. But the other thing that the courts are sometimes doing is, they are saying, no, you have some vested interest. Vested interest to bahut logon ka hota hai na. See, the thing is, if ho sakta hai, meaning ki I may have been personally affected by some act of corruption of, say, whatever, Adani or Reliance and so on. And therefore, I gather all the information about the corruption of Adani and I file a PIL about that corruption. Now, the fact that I have also some axe to grind doesn't mean that I am disentitled from filing that PIL. Only thing that the court needs to be careful in such cases is that if it appears at any stage that it is being used as an instrument of blackmail, then the court should appoint an amicus.
Absolutely.
Thank you, sir. I'm most grateful.
Thank you, Sanjay ji. So there's a question from Mr. Pranav Sarthi. Sarthi ji, would you want to ask your question?
Yes. Good afternoon, sir. My question is related to the prayers that are to be made in the PIL. If you could briefly explain, sir, the prayers to be made in a writ PIL, vis-a-vis the 5 prerogative writs that we have.
So the prayer can be anything where the court's order will redress some rights of people, redress some public harm that is being done. Any prayer where the court's order will redress the violation of rights of the people, or will take some public interest forward, can be made. But as I said, you have to very, very carefully understand what is the best solution, what is the correct solution to this problem, and therefore consult the best experts, find out the best information, consult the best experts on the subject, and also disclose in your petition what are the legal rights which are affected, and therefore what are the rights for which you are seeking redress. Because in order to be judicially manageable, you have to show that the court has jurisdiction to pass such an order. And there you have to bring in somebody's rights which are being affected, or some provision of law or the constitution that is being violated.
Right. Thank you, sir. Thank you.
Thank you so much, Sarthi. So there's a question from Mr. Reynold Nongdhar. So his mic is not working, so he's asked me to ask this question, again related to RTI. He asks why RTI does not cover against private companies.
Yeah, that's very simple, you see, because what a private person or private company does is not really a matter which necessarily concerns public interest. And see, the principle for public authorities being made answerable under RTI is because the people are supposed to be the masters of public servants and public authorities. And therefore, they have a right to know what they are doing. But the people are not masters of any other private company or a private person. So you can't, there they have a right of privacy, and they will say, what is your right to know what I am doing or what I am not doing, what a private company is doing or not doing, unless, so the RTI Act says, any information which a public authority can access from a private, can legally access from a private person or a private body, is also available under RTI. That means that some public authority should have under the law a legal right to obtain information from that private company or that private body. For example, every private company is supposed to file their accounts in the Ministry of Corporate Affairs website. So to that extent, you can ask the Ministry of Corporate Affairs, what is it that these people have disclosed by way of their accounts? So whatever the private company is obliged under the law to provide to public authorities, that information of that private company or that private body can also be accessed under RTI, but not every information.
Done. I think that very well puts it, sir. So there is this question from Mr. Piyush Singh. So he asks, it's a very, I think he wants some, again, lots of people, they love you. So his question is, can you please throw some light on how you prepared for the case of Jacob Puliel versus Union of India regarding vaccination policies?
Yeah, so actually, Jacob Puliel is firstly a friend for whom I was doing another case also involving vaccines. He is himself an expert on vaccines and was a member of the National Technical Advisory Group on Immunization, which is the kind of apex technical body on vaccines in India. But apart from that, you see, because of my general interest in such issues and because of the early information that Dr. Pulial kept sending me, I had been following and I had been studying this whole COVID and how dangerous is it, how infectious is it, whether the vaccines have been properly tested or not, whether vaccines actually work or not. There was a general narrative which had been spun out by various governments and by various authorities. And there was a counter narrative also, but that counter narrative was being suppressed. And therefore, in order to get to that narrative, you had to dig in places which were not very common or popular and get access to information or papers or research done by people whose research was not coming out in the mainstream media. So it was difficult, but because of Dr. Pulial and some other people like Dr. Peter McCullough, etc., that I came to know, who had been writing and researching this. These are some of the world's top experts, or people like Jayant Bhattacharya of Stanford, Sunetra Gupta of Oxford, etc., who had written what is called the Great Barrington Declaration against lockdowns, etc., pointing out that these lockdowns were counterproductive. So I had been spending a lot of time reading about all this because of my personal interest in the matter, because of my relationship with Dr. Pulial. After we felt that we had sufficient information and understanding of this, and when we found that vaccine mandates were also getting enforced in India, people were being told that you will not be allowed to access this service or that service if you don't get vaccinated. I was totally opposed to vaccination because I had understood early on that vaccines do not prevent the spread of the virus. They do not even help in preventing hospitalization, that vaccines also have several serious side effects, etc. So I never got myself vaccinated either. I have not been vaccinated. And so therefore, for me, it was not difficult to take up Dr. Pulial's case on vaccines, etc. But that's because of my relationship with him, his expertise on the matter, because of my interest in this issue, because I had been spending a lot of time reading up this stuff, etc.
No, but it's absolutely remarkable because I understand the kind of effort that would have gone into such unique research. So just a few more questions. I think so. There's one question from Kashyap Law Offices. I don't know your name, sir. Would you want to ask the question yourself, or should I ask the question for you? Okay, so I'll ask the question. So they're saying the mic is not working. That under what circumstances a writ under Article 226 can be converted into a PIL?
You see, these are just technical things. The point is, if it's a petition where you are espousing the interests of people other than you also, then it's a PIL. If you are espousing only your personal interest in the matter, or your personal stakes in the matter, then it's a regular writ. So, for example, if you go and seek your promotion, that's a regular writ petition. If you have not been promoted wrongfully, etc. If you seek the removal of a particular, say, chairman of your organization on the ground that he has been illegally appointed, that's a PIL, because unless you have applied for that post yourself, it can be treated as a regular writ because your interest is directly affected. But otherwise, if it's just a quo warranto because of illegal appointment, and you have not applied for that post, that's a PIL. There can be hybrids where you are also interested, but you are also espousing the cause of a large number of other people. That's a PIL then.
Thank you, sir. Thank you so much. So, there is this one question. There is this one question from Mr. Rahul Rajiv. So he asks your opinion.
So last question now, because
Yes,
I'll have
last, sir, but you'll have to permit me one question from my end, sir.
Sure. Go ahead.
Thank you so much, sir. So from Mr. Rahul Rajiv, there's this one last question, sir. He says that sometimes courts have been accused of overstepping their jurisdiction and encroaching up the domain of executive and legislature while dealing with PIL. So what is your opinion about it?
Yeah, so sometimes it has happened. So, for example, the distinction is the following. If the judge or the court is trying to substitute its own opinion for the opinion of the executive or the opinion of the legislature on any matter, where that view does not involve any legal rights or any constitutional rights of people. For example, government say adopts a policy of, let's say, we will allow only people of 5 years plus to go to class 1. Suppose that's a policy taken by the government. Now, the judge feels that any people below 5 years should also be allowed to go to class 1. And therefore, he says, I'll pass an order that people below the age of 5 should also be allowed to enroll in class 1. Now, there are no legal rights of anybody which are involved. When you are saying, and if you try and say, no, I am saying that to go to class 1 below 5 years is also a legal right under Article 21, that's a very long stretch. Firstly, the judge cannot say, look, in my opinion, this should also be done. That's not the job of a judge to override the opinion of an elected government or a policy decision of an elected government. The judge has to show that this decision is violating these fundamental rights of these people or violating this provision of the Constitution. Then only, or this policy is violating these fundamental rights. This policy is discriminatory and therefore violates Article 14, etc. Then he can certainly make an order. But not just because in his view this is the right thing to do, because there you have to leave it to the wisdom of the elected government and their experts, etc. Unless you can show that this violates some rights.
So thank you so much, sir. Very well put. And it's just been absolutely fantastic listening to all of these things from you. Now, sir, I have very humbly, I have 3 questions, sir. I leave up to you, whichever one you think best that you want to share some insights on. So one is pro bono work for young lawyers. What are your thoughts, views, opinions, ideas, anything? So second is misinformation through advertisements. How advertisements can invariably be construed and used as a mode to possibly inflict thoughts and ideas into people's mind, which may necessarily not be in their interest and in their favor. And so the third is role of education in building an empowered society, or more so legal education, how we're doing it over here right now. So either of the 3, so since we've already overstepped the time that we've asked of you, so any one of them.
I'll try and answer all 3 of them quickly.
Wow, sir.
So pro bono work, I feel that public interest litigation should be done pro bono, and lawyers should be doing it pro bono. You shouldn't be charging for public interest litigation. Now, one question that is asked is how will a lawyer sort of, how will he manage if he is doing public interest litigation pro bono? He can manage with his other cases, and the public interest litigation, if he does it properly and well, gives him enough visibility in court, and also judges also start respecting you when they see you doing some serious pro bono public interest litigation. So you will get other cases, more cases, and therefore your overall income normally does not suffer unless you are restricting yourself only to pro bono PILs. So my advice is don't restrict yourself only to PILs. Yes, any good lawyer should do some PILs, but you don't need to restrict yourself. I do mostly PILs, but I also do some other cases, which give me enough income for my whatever my needs are. Now, second question was about misinformation in advertisements. Now, this is a major problem actually. This is a more deeper and more general problem in society today, that not only are we being fed a lot of misinformation, but unfortunately sometimes, as I saw in COVID, the correct information is being censored. It's being censored by the government. It's being censored by even these big social media platforms like Google, Facebook, Twitter, etc. They were also censoring the correct information, because if there is a big commercial vested interest involved, in this case of pharmaceutical vaccine companies, then all contrary information was being censored. There was a concerted effort to create fear around COVID so that people will be forced to take these vaccines, etc. And all the big social media giants also got involved in that censorship. In such situations, it becomes very difficult for even reasonable thinking people to really know what is true and what is false. Because when only misinformation is being fed and the correct information is being censored, it becomes a huge problem. This is a major problem that we need to find a solution to. And it's also leading to, social media today is also leading to polarization of society. There's a film called The Social Dilemma. I think it's on Netflix or something, which tells you why social media is leading to polarization of society. Because if you watch something on YouTube, YouTube will throw at you similar things, which espouse similar views or similar content. And therefore, gradually you get polarized on one side. Other people who are watching very different things will be fed those kind of things on their YouTube, and therefore their views get polarized on the other side. They don't get to see, each of them doesn't get to see what the other side is seeing. So this is a problem which we need to deal with. I'm not sure exactly how to deal with it, but certainly it's a serious problem. Your third question was, kya tha tumhara last?
So third question is with respect to the role of education for building an empowered society. So like this. So more so, I would say more specifically legal education. So professional.
Yeah. So education is certainly very, very important in an empowered society. Education, information, the right information, and the right education. The only problem is that sometimes you don't get the right information, you are fed the wrong information. And even the education, just say now today curriculum is being changed to remove big chunks of history. The curriculum is being changed to remove Darwin's theory of evolution, to remove the periodic table and so on. So you can get the wrong kind of education also these days. So, but certainly correct education and correct information is extremely important in any for any society. But the most important thing for any human being is to, to improve the level of critical thinking. I keep saying that there should be only two objectives of education. One is to enhance your capacity for critical thinking, to be able to distinguish truth from falsehood, to be able to question everything. That's the most important object of education. The second object of education is, or should be, to make you sensitive to what's happening in society, to how other people are living, to other beings in society, to the environment in general. That is a very good capacity for critical thinking and reasoning. And B, a awareness and sensitivity to other people, to other beings, to the environment in general. He will become a fine human being. Those are the kind of people we need in our society. People who have a very enhanced capacity of reasoning and critical thinking, and people who are sensitive to other people. That's what we need.
What do I say? Thank you so much. It's been very enlightening, and I'm quite sure that a lot of what you've said, everyone will want to go over that once again. I know for sure that handling all of this muting and unmuting, I will have to absolutely go back to this class once again. And so absolutely enlightening. Sir, I'll just, if with your permission, since we are already taking more time of yours, that's I've done my master's in public relations before doing my LLB. So there's this one person, if I have your 2 minutes indulgence.
Yes,
He's
sure.
called Mr. Edward Bernays. He's called the father of public relations, the father of spin, how they call it. So a lot of very interesting things I got to read, sir, how actually manipulation is done and how advertisement and marketing, how they actually play such vital roles. And most of the time, sir, it's very unfortunate, but I understand that people are not even, it's not that people are conniving or there's a conspiracy, it's just the mere fact that people are absolutely, how do I say, politely putting it, imbeciles. They do not even understand what they are doing and the repercussions and implications of what is going to happen. But as long as we have such champions as yourself and sir, all the seniors of the bar who so kindly come out, take out their time on a Sunday and try to teach us young guys how to move forward, how to proceed in life. So it's just a blessing. And it actually makes us feel very, how do I say, so loved, cherished, and gives us inspiration to grow, sir. Thank you so much, sir, for your kind support, your blessings, and your guidance, sir. Most valuable guidance, sir.
Thank you, Keshav. It's been a pleasure. Thank you.
I thank
Sir, from all the participants, I also convey my gratitude.
Sir, I very humbly introduce you to Dr. Sai Kumar, sir. Sir, he's one of our, how do I say, some mentors, guides, patrons. Sir, he's one of the reasons why these classes, they do occur, that they happen. It's a privilege, sir, to be able to introduce you to Sai, sir. Sir, he's introduced me to the field of law. He's been my first guru in law.
Yeah, I only motivated him, and this has reached so much. Today, I'm very happy, and sir, very lucid language, and absolutely, actually, we must learn how to speak from you.
Thank you very much.
Yeah, very nice, very lively. It is lively.
Thank you. Thank you.
Thank you so much, Prashant, sir. Thank you so much, Sai, sir. Thank you so much.
Thank you so much,
Sir,
sir.
only
So, sir, with your permission, I'll end the class now. Thank you so much.
only one question.
Sir, I think he is disconnected now.
Achha.
So I just end the class, sir.
Okay,
you so
next
much.
time, yes, they don't follow High Court, Supreme Court judgment. What is to be done?
Absolutely, sir. Thank you so much.
Okay,
Thank you.
bye.